Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and it's a place for thoughtful conversations. We have conversations ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. For today's episode, I'm joined by Tim Wilkins, and one of the things that I want to do this year is get better at introducing my colleagues because they're familiar to me. I'm not sure that they're familiar to you. If they are familiar to you in our audience, there may be some who have never heard of these guests. I'm pretty good about introducing our out-of-firm guests, but I need to do that same treatment to the partners and associates I get to enjoy working with. And so I want to introduce Tim Wilkins or reintroduce him. I'm sure if you're a listener of this podcast, you'll be familiar with him. But Tim and I have been working together since my day one at Bracewell. He's in the Austin office with me, and we do a lot of environmental auditing work together. And that's going to be the subject of our conversation. And so I've been working on audits with Tim since I started working at the firm. But Tim's had a really unique role in the development of environmental auditing over the course of his career. I think it'd be worth exploring that as we talk about the purpose of environmental audits and then maybe why companies should be actively conducting environmental audits. If you'll remember, we had Tim on a couple episodes ago on our holiday episode, and we talked a little bit briefly about the importance of environmental auditing, how that makes for a good New Year's resolution for a lot of companies. And so I thought we'd just have a nice conversation on that topic. So welcome back to the show, Tim.
Hey, thank you, Daniel.
So you've told me this story a few times, but I don't think that we've put it out in the environmental law monitor world. You've had, I think, from my perspective, a unique experience with the whole discipline and practice of environmental auditing, as well as some of the sort of headier concepts behind the purposes of environmental auditing and why it makes sense for companies to have environmental audit programs, why it makes sense for environmental agencies to stand up environmental audit programs. And so before we talk about your history, I think it's good to set the table and to define our terms. What are we talking about when we talk about environmental auditing? And I could hazard my own definition into our audience, but I think while we have you here, what do you think of as environmental auditing?
Yeah, to start with what it's not, I think a lot of people think when an agency comes in and audits your compliance with environmental law as part of their enforcement approach or their inspection approach, some people refer to that as, I've been audited by TCEQ or by EPA.
That's sort of like an IRS audit, right?
Exactly. That's kind of the idea. And I think there's some common usage around that, but that's really not what we're referring to when we're talking about auditing. When at least I'm speaking about environmental auditing, I'm thinking of environmental self-audits, a self-examination of your compliance with respect to the laws, regulations, permits, other requirements that are applicable to a given facility. And again, it's more akin to the internal audit function that people do as part of their financials or as part of their SEC reporting, things like that. It is a self-check on how you're doing relative to the applicable standards and requirements. So that's in a very brief phrase when I think environmental auditing. That's the approach I'm describing.
So take us back in time a little bit to what got you thinking about the idea of environmental self-auditing in the first place. And you don't have to give a year. We don't need to talk about dates or anything. But when did you start thinking about environmental auditing? What put the idea of auditing on your radar?
So I was in law school and graduate school. I am a proud graduate of the joint degree program between the Kennedy School of Government and the Harvard Law School. And that interplay between law and policy in the administrative law world and the agency world is something that was super interesting to me. And as a first-year summer associate after my first year of law school, I clerked in Bracewell's Houston office and went to work for a gentleman by the name of Terrell Hunt, who was the immediate past head of EPA's Office of Enforcement Policy. And one of the things in our numerous conversations that summer that came up was some stuff that was kind of fresh in the news at that time about EPA and even some of the criminal enforcers going after self-audit information at some of the big companies. I think Weyerhaeuser and Coors were examples that had been much in the news at the time, where basically those companies had internal audit programs on environmental stuff, and the enforcement authorities said, yeah, hand those over and use those documents as a roadmap to enforcement actions. To me, as a policy junkie, that was a terrible, terrible incentive to set up. The idea that somebody who is doing internal self-criticism and trying to get better, and you turn around and hit them in the mouth with the very good stuff that you want them to be doing to try and get better, that struck me as terrible.
And that seems like the playground tough kid grabbing your hand, making you slap yourself while saying, stop hitting yourself, stop hitting yourself.
Exactly. There was definitely an element of that. And I understand environmental regulators saying, but we know about these violations and our job is to enforce that stuff. But I think there was, at the time, sort of a groundswell in favor of the concept that inspectors can't be on the ground everywhere all the time in the environmental context. And if we were to say, hey, let's harness the power of these self-audit programs that responsible companies are trying to pursue, you could really incentivize a lot of good behavior, a lot of improvements to compliance. The idea that we're not going to punish somebody who finds and fixes their own problems, that's something to try and encourage as a policy matter.
And so that was in the ether when you were doing your first summer at Bracewell. And then what did you do with that? Take us from you learning about audits, thinking about this kind of policy problem, wanting to leverage all of the compliance officials, companies to do the work of self-assessment and correction, because state agencies, EPA, they have finite resources. Why not leverage the resources of the private sector as well?
Yeah, I dove in. At that moment, I saw an opportunity for a really cool law review article that Terrell and I could write together. And we did, called Environmental Audits and Enforcement Policy. And it started from the proposition that self-auditing is a good thing to be encouraged, talked about the availability of privileges, whether that be attorney-client communication privilege, attorney work product doctrine, self-critical analysis, or other common law type privileges, the availability of those things so that companies can do the right work without it being used against them. But then also talked about, how that interplayed with the agency world and what agencies might do to encourage auditing without cutting everybody loose from responsibility. It ended up being a very popular article published in the Harvard Environmental Law Review. It was used as evidence in testimony in legislatures around the country in 91, 92, 93, 94, when a lot of state legislators took up the cause of state environmental audit privileges or state environmental disclosure statutes or policies. So the article became pretty famous pretty quickly. It was heady stuff for, somebody who was still a law student when I wrote that stuff. But again, it was I think a good instinct. I had a lot of help from Terrell, had a lot of help from Cabell Acree, who was an associate working in that group at the time. And to me, that was just a great development that we could really use to further good policy. But it also struck me that the idea of auditing as a good that companies should be doing, and the idea of privileges, whether those be attorney-client or statutory, the idea of disclosure opportunities that were beginning to develop in those states, that became a very important practice that we could sell to our clients and help them do the right thing. So a lot of stars fell into alignment for all of that to happen. But that's the origin story. That's how I got involved in it, and that's how a lot of that stuff developed.
So, and we'll turn here in a second to getting a little bit more granular on why companies should be considering environmental self-auditing as part of their routine business practice. But and obviously you've guided clients through, thousands of audits in your career at this point. But have you continued to be involved with the development of audit policies? Have you spoken with environmental committees and state legislatures to discuss audit programs and so on? Like, what's your continued involvement on the policy side?
So I have recently provided input to the state of Louisiana on a statute that they ended up adopting that relates to environmental auditing and audit privilege issues. The biggest sort of policy development was participating in kind of a working group that EPA set up at the federal level on the idea of new owner audits, the idea of using EPA's audit policy from 2000, the idea that you find, fix, and disclose in exchange for penalty leniency, applying that in transactional contexts where a new owner of stock or assets could take advantage of the idea that I'm going to go turn over a bunch of rocks, find the things that are broken, go into the agency and fix them. But I can't live with, for example, a 21-day disclosure or a 60-day corrective action timeline. You need, when you're digesting a new acquisition, a lot more time than that. Flexibility in how those audits get evaluated by the agency, some of the terms of EPA's audit policy. So that was something that took place in 2005, 6, 7. I'd done new owner audits under agreement with EPA before there was like a formal policy around that. And in 2008, EPA adopted the so-called interim approach to applying the environmental audit policy in a transactional context. I was involved in the development of that and have remained involved in that through being one of the real frequent flyers at EPA on the new owner audit program. They take a lot of how they apply that program from new owner audits that I've done with them over time.
You probably don't get any points or rewards from EPA for being that kind of frequent flyer.
It's not a point system for sure.
Well, I was thinking, I guess until recently, that I would probably describe you as like the Tom Brady of environmental auditing. But between the last season with the Buccaneers and the whole FTX implosion, I think I'm going to have to come up with a better simile. So let's talk a little bit about why companies should consider conducting environmental audits. And we work with companies, plenty of companies are doing this, but for companies that don't really think about environmental auditing as part of a routine business practice, what are the real purposes underlying these audits?
These days, big companies in heavily regulated industries are going to have strong compliance programs. They're going to have smart people working in the EHS space that understand the regulations, that have SOPs or that have procedures, have lists of applicable requirements that they use to make sure that they're staying in compliance as best as possible. What environmental audits do is provide a periodic, systematic, candid, thorough check that those systems are still working. I like to say that laws change, people leave, equipment breaks, processes get modified. All of those things can take you from being in compliance to out of compliance in a heartbeat. And if you just keep doing what you're doing, you may miss that, right? So I think it's important to have fresh eyes on a periodic basis, take a look at compliance, company-wide, system-wide, facility by facility, activity by activity. I think it's important to have that sort of level of check. And I think it depends what's the degree of flux at a facility or in a given area of law. I think, how high risk from a regulatory perspective your activities are. Are there new lenses that you look at stuff through? For example, the scrutiny that's coming from environmental justice is a problem that was minor 2 years ago, suddenly major because enforcers are looking at it in a different way. So environmental auditing is really sort of an internal technique to make sure that your systems are working, but it's also an opportunity to get ahead of the regulators from an enforcement perspective. You don't want to be in enforcement. You don't want to pay penalties. If there are ways to make sure that when that inspector shows up from an agency, that things are shipshape, that's a function that environmental auditing can serve. I would also say that these audits are really a great opportunity for people to learn about new stuff that's applicable. People that are auditing different companies and different facilities, people who are in the consulting world, people in the legal world, see multiple scenarios. They have an exposure to an array of stuff within industries and across industries that can really be sort of new and different information that companies, individuals may not be getting. So I think environmental auditing really is a great internal feature, external defense feature, and a real learning opportunity to make sure that folks are doing the very best that they can in terms of compliance.
And I think for new employees, for junior members of compliance teams, environmental auditing programs are also great on-ramps to understanding more about environmental law, because some requirement may be pretty standard at a particular facility and well understood by more senior compliance members. It's still going to be new to somebody. And if you are trying to train up junior associates or new members to a compliance team, I think conducting environmental audits is a great way to help those individuals have a bigger picture view of what's going on at a facility and to have encounters with basic environmental laws in a way that they are digesting and analyzing and then putting into action and making judgments about whether this facility is in compliance with, X, Y, or Z requirements or not.
I mean, all of that is true. You can get an overview of what the environmental laws require in a seminar, in a CLE that says, here's what the environmental laws are. But auditing is this review of how the law applies to the facts. And it's really, I think, something that opens people's eyes going through the audit process. And there's some pushing back and forth that can happen. It's like, well, but I think this exemption applies. Well, let's explore the limits of that. Mm-hmm. By taking an individual facility or operation, looking at how that reg or how that permit applies and, trying to do your very best to figure out, is this compliant? Is there something else that we should be doing that would be better? That exercise, I think, really helps people understand the contours of what the requirements are.
So we've talked about the value of conducting internal compliance audits. Obviously, from the enforcement perspective, getting ahead of the regulator, avoiding penalties or at least mitigating penalties depending on the specifics of the audit policy or program. Talked about the importance of digesting new information, whether that's in the form of a guidance document or a new regulation, truing up old permits that may describe outdated processes and all of that. But what, in your experience and in your time leading companies through audits, what are some of the basic things that companies may get wrong about environmental audits, either sort of in the big picture perspective of what do they think or do or not do about environmental audits, and then in the execution of a particular audit, what might a company get wrong?
Yeah, I think there are a number of companies out there that have a little bit of overconfidence in their systems. They think that the systems have got it covered. We're doing compliance. We've had good results from agency inspections, so we don't really need to worry about independent or third party or fresh eyes kind of audits. And I think that's a mistake. You don't need to do that every time. You don't need to do that every year, but on some periodic basis, every 3 years, every 5 years, it really, I think, is meaningful to have fresh eyes take a peek at that stuff. I think, second, companies that aren't quite sure what they're going to find sometimes proceed without invoking relevant privilege protections. If you don't know what you're going to find in an audit and you turn over that rock and find something pretty bad, you not only have documented the existence of the violation, you now have knowledge of the violation, and it can create real pressures on companies to address stuff. But I think equally importantly, it creates real evidence that can be used against a company, not only, again, of a severe or more significant violation, but knowledge of that violation. And, what do you do in that context? I think there's real benefit when you're not sure what you're going to find, when you don't have a real bead on how things are going from a compliance perspective, to invoke attorney-client privilege, or if you've got available state law privileges to take advantage of those things. I think that's sort of important to consider.
And that's a pretty natural thing to want to do if you're worried about a possible problem, you don't have full vision of what that problem might be. I think our instinct is always to just run at that problem, try to understand it. And then once you've understood the problem, to then move on and start to address it through corrective action or whatever you need to do. And I think what we're talking about is when you have the hackles raise up on your neck, right? When you're worried that there could be a problem out there, not to delay, but definitely to take a beat and to think about whether you want to have all discussions about that issue under appropriate privilege controls or whether it's possible to send in a notice of audit to a state regulator.
Yeah, and that last point is a good one. There are 3 states now, Texas, Oklahoma, North Dakota, that have a notice of audit requirement. You have to notify the agency before you commence the audit if you want to be eligible for audit disclosure and penalty relief if you find, fix, and disclose. And I do think that there is a real phenomenon out there where smart EHS folks, smart engineers get an inkling that something may not be going quite right. And the first instinct is, I've been told over and over and over again, to come to my boss with solutions, not problems. So I'm going to go dig in. I'm going to figure out what's broken. I'm going to run it to ground. I'm going to do that regulatory analysis. If you've done all of that work and you have not first submitted that notice of audit to, again, Texas, Oklahoma, North Dakota, you run the risk that you are not eligible for audit disclosure related relief. In those states, you have to notify the agency before you commence the audit if you're going to get any penalty relief. And Texas is obviously nearest and dearest on that. But I think a lot of folks will dig too deeply when they get the first inkling of a problem rather than saying, you know what, we should audit that. We should send in a notice of audit and we should do a thorough examination of what the compliance issues are around this facility or around this piece of a facility, around this program. When you just get that feeling that stuff may not be managed quite right, that's an important moment to say, I think I can take advantage of these audit tools and get penalty relief. But I've got to go through some choreography first. I've got to send in some notices. I need to understand what the information needs are for this audit process. I need to know who I'm going to disclose to, how fast I have to disclose to them, how fast I need to jump into action to correct. Those are all things to, again, as you said, take a beat or hit just momentary pause while you sort through that so you know how you're proceeding with that potential problem that you've become concerned about.
One thing I definitely worried about when I was first assisting you on some of these internal compliance audits was, here we are, we've identified violations. Let's say company changed some operations and didn't update their air permit, although they have, some slightly increased emissions. The operations have changed. We want to make sure that the face of the permit reflects operations on the ground. And so maybe a company has an outdated air permit. One of the things I worried about, especially in the beginning, is that, basically what you're doing when you're disclosing a violation is you're almost like confessing to an agency, right? And one of the things I just wondered about is, what's the perspective of the agency when you approach them with disclosure of a violation or of multiple violations? In your experience, have companies been worried about disclosing violations to state agencies out of the fear that the agencies might come back on them, sort of as you were describing in the very beginning? Are they going to, sort of read through the lines of an audit disclosure and find other things to enforce against a particular business? And are those worries ever justified in your experience?
I definitely encounter companies who are not experienced with audit disclosure, who are afraid of the audit disclosure for those very reasons. At the EPA level, for example, it's a policy. It's not binding. It's not like the Texas statute, which says you are statutorily immune if you check these boxes. EPA is a different world. Now, I've found that EPA, by and large, honors the words of their policy and gives penalty relief where you've qualified for that audit policy. There are a bunch of states that have audit policies or even audit statutes on the books that have no real experience with them. I had an experience with a state in the West recently, where the permitting authority and the enforcement authority for air issues had absolutely no awareness that there was an audit policy on the books. Or an audit statute on the books, frankly. I would worry about sending in an audit disclosure to an agency that just had no experience with that and hoping that they would know how to implement it or wouldn't react badly. In Texas, where they're literally processing thousands of these a year, I think most folks who have had any experience with the Texas Audit Privilege Act realize that this is a state where you can disclose with some degree of comfort that there's not going to be that negative reaction. In fact, that the state looks at you as a hero for self-identifying the violation and self-correcting the violation before they had to get involved, before TCEQ had to get involved. So I think it's different states. I think it's context. I think you just need to be careful on that. But I've definitely encountered companies who were really nervous about this enterprise and had to have me explain, look, I've done literally hundreds of these audit disclosures to TCEQ, and the response is a positive one every time. You do what you're supposed to do, and you're going to get out of this without a penalty. There's sometimes some explanation to do to get comfort built there. But I think, with the state of Texas, there's a real compliance culture that says if you do audits, if you find, fix, and disclose, you follow our steps, you're going to be treated fairly by that agency.
Yeah, that's been consistent with my experience too. You may get a follow-up question asking for a little bit of extra detail so that the agency can understand the violation or the corrective action that you're implementing. An agency may have some comments on your corrective action plan. When you discuss any identified compliance concerns with them, at least at TCEQ, it's much more of in that compliance assistance and compliance assurance posture than a gotcha posture.
That's right. I mean, the agency staff that works on audits, these are very competent, very sharp people, and they don't want to be taken advantage of. They don't want somebody saying they've done something that they haven't done. So there are follow-up questions, but they're respectful follow-up questions. They are smart follow-up questions. And again, at the end of the day, you're certifying compliance with this stuff. If you're lying to the state, you've got a bigger problem than whether the Audit Act's going to apply.
That's right. That's right. And, and the TCEQ audit team they want to protect the audit program so that it benefits as many people in the state as it possibly can.
For sure.
And that's why there are good faith requirements and all of that. Any other concluding thoughts, Tim, before we let you get back to maybe audits, maybe something else that's on your plate for the day? Any other thoughts about how companies can improve their ability to take advantage of audit programs, either at the state or federal levels?
Well, I've talked a lot about how some companies that I've encountered have compliance programs and systems that they rely on and don't feel like they need audits as a result of it. I think there are also companies that have audit systems that they have not refreshed. And I think it can be very useful to refresh how you think about your audits and to see if there are ways of improving the bang for the buck that you're getting out of it, to spot whether there have been problems created by the way or the sequence or the logistics of how you've proceeded with your audits. There are new technologies out there that allow people to literally live record what they're doing walking around during an audit. So somebody can zoom in to participate in an audit and answer questions. And I mean, there are so many things that have changed with the pandemic and the new technologies that people have really embraced trying to get together remotely. Those are technologies that can be brought to bear on audits and the like. So I think refreshing the audit program that you've got to make sure that it is giving you the maximum payoff is one more thing that I would encourage people to consider.
Well, and I know that you're available if anyone listening wants to work through some of those ideas and conduct a refresh. So thank you for coming on the program as usual, Tim, and we will look forward to following up with you later on what you're working on and any new developments in the audit space. Thanks.
That sounds great, Daniel. Thanks for having me.
That's it for us today at the Environmental Law Monitor. Big thanks to our guests, as well as Dorn, Emily, and Austin, and the rest of our production team who helped to make this episode possible. And of course, thank you, our listeners, and we'll talk to you soon.